Good evening and welcome everyone to the Orange County Clerk of Courts Legal Matters Forum. Our presentation tonight is on probate, wills, trusts, and estate planning. I'm Dane Weister, the Communications Director for the Clerk of Courts and your host tonight. We thank you for joining us and we hope that you'll find the information that's provided to you this evening very helpful. These are free legal forms that we put on as a service to the public. Now, there'll be presentations. And then after those presentations, you'll be able to submit any questions you have through the Q&A function that you see at the bottom of your screen. No need to raise your hand and so forth. Just submit your questions and we'll verbally go through them and provide your answers once our presentations are completed. There will also be a survey to fill out at the end of the webinar. That helps us as we plan these in the future. In addition to our Zoom platform, we are broadcasting this via our Facebook page, the Orange County Clerk of Courts Facebook page, and we'll be posting and recording it on our website and social media channels for future reference as well. So now I would like to introduce you to your Orange County Clerk of Courts, Tiffany Moore Russell.
Thank you, Dane, and hello, everyone. Thank you so much for being with us today. We know this is a timely and crucial topic to discuss in today's environment. This webinar discussion will take an in-depth look at the probate process and help provide you with information regarding your legal rights. One of my office's strategic outreach goals is access to justice. I personally had Legal Matters created as a service for the public to make legal information easier to understand and more accessible. These forums are designed to give our citizens more access to justice and access to the information they have the right to know. So I want to take the time to acknowledge my staff who have worked hard to bring this webinar to fruition, as well as acknowledge our panelists who are with us today. From my office, we have Probate Mental Health Operations Manager Michael San Giorgio. From Aris Law, Attorney Karen Skyers. From JP Law and Wealth, Attorney Loire Jean-Pierre. And from the Ninth Judicial Circuit, we have the Honorable Judge Mike Murphy to bring the judicial perspective from the bench. Again, thank you all for taking time to be with us this evening. And I thank you all to our panelists for sharing your valuable legal information for us. So enjoy the forum, and I give it back to you, Dane. Thank you.
Hey, thank you, Clerk Russell. So just to let everybody know, as we were sharing, this is being recorded, shared on Zoom where you're watching it from. We'll also have it later on the Orange County Clerk of Courts website. We were trying to stream it live on our Facebook page, but technical issues there, so that's not happening. We'll see if we can get it back up later on. But if you're looking to view this at a later date, share it with anybody you know, family, friends, it will be on our website in the future. All right, so let's get into it. Without any further ado, let me jump into the heart of our legal forum. And first up, we have attorney Karen Skyers with Aris Law, who will share with us estate planning, that process, and why that's so important. Hi, Karen.
Hi, thank you so much to Honorable Clerk Moore Russell, her amazing staff. Thank you so much to my co-panelists and guests today to talk about this very important topic that touches us at some point in our lives, because we all know that death is certain, right? We're all going to die someday. And what does that mean? So estate planning is such a crucial process to help individuals manage their assets during their lifetime, and it ensures a seamless transition to their heirs after death. So this presentation is going to cover the importance of estate planning. You're going to learn today about what probate is. I'm going to talk to you a little bit about ways to avoid probate and advance directives. So I'll move on to my next slide. Just to give you a little bit background, my name is Karen Skyers. I'm a proud partner at Aris Law with my partner, Ruby Montez. We serve all of Florida with offices in Tampa, Brandon, Orlando, and Plant City. We also serve New York. Between the both of us, we have a combined experience of about 30 years. And we are all bilingual. We speak Spanish. So next slide. We're going to talk about estate planning and why it's vital for everyone who wishes to ensure that their assets are managed effectively and distributed according to their wishes. Understanding its importance can lead to peace of mind for your individuals and for your families. Next slide. The importance of estate planning is going to be to allow individuals to dictate now while they are of sound mind and body on how to distribute those assets, how to minimize taxes, and provide for their loved ones when they are no longer here. It's also going to avoid conflicts among heirs and ensures that your personal wishes are honored, right? We'll talk about number one. A detailed plan removes uncertainty and provides clear instructions when you are no longer here. It ensures that your assets, like your property, investments, and personal belongings, are distributed according exactly to your individual wishes, avoiding the default decisions that are made by the court, right? Think about what happens to your children. Who's going to care for them when you are no longer here? Will they end up in foster care? Could happen. We'll talk about tax minimization, right? A well-structured plan can help minimize taxes for heirs and then preserves more wealth for future generation. Why that is so important? Because you want to save on your taxes, right? Reduce the estate tax, inheritance, and gift taxes. So our goal is to show that good planning isn't just about distributing assets, it's about keeping as much of the estate intact as possible for your loved ones. Conflict avoidance, this is a big one. Proper estate planning helps to avoid potential conflicts among heirs, promoting harmony and peace amongst family. Misunderstandings and disputes can arise when there is no plan or when a plan is unclear. So by having a detailed plan, transparent documentations, families can avoid costly and emotional conflict during a time of trauma, right? When somebody dies, that's what happens. We're sad. So we'll also talk about how you appoint neutral executors or trustees and holding family meetings to maintain unity, right? Because how many times have you heard, grandma left me the house? You want to avoid those things. Honoring personal wishes. Estate planning is going to ensure that your personal wishes regarding asset distribution and care are respected and honored. So we'll focus on personal autonomy, right? It's not only about, again, managing your assets, but it's going to respect your personal values, whether that's caring for a dependent, making charitable donations, or determining your healthcare wishes, like documents through a living will and a healthcare proxy, which I'll talk about next. So next slide. What is probate? Probate is the legal process, right? We've all heard about probate this, probate that. What it is, it's the legal process of validating a will and distributing a deceased person's assets. Understanding how probate works in Florida is crucial for effective estate planning. Next slide. In Florida, the probate process is quite lengthy, very expensive. The first step would be in the probate process is to file the deceased will with the probate court to initiate those proceedings. The next step would be appointing a personal representative. A personal representative is appointed by the court to manage the probate process and oversee the distribution of those assets. Then, collecting assets. The personal representative will have the job of collecting all of the assets, but they're not able to distribute any of those assets during the probate process. So most of those assets and accounts are frozen during the probate process. Next step would be settling debts. So before the personal representative is able to distribute those assets, the personal representative must settle any debts or obligations of the deceased, ensuring that all creditors are paid, and even filing a notice in the local newspaper to let creditors know that they have to file a claim. Here in Florida, it's 90 days. So distributing assets would be the final step. Once those debts are settled, the remaining assets are distributed to the heirs as outlined in the will. But before that happens, the attorney who helps you must be paid. And what does the Florida state law say? Lawyers are paid 3% of the total value of your estate. So why this is so important. Next slide. I'm going to talk to you now about 3 ways to avoid probate, right? One of the, there's several strategies to avoid probate, including joint ownership, we'll talk about beneficiary designations, and then we'll talk about establishing a revocable living trust. So each of those methods has its own implications and benefits. So next slide, I'm going to talk to you about joint ownership. One of the ways to avoid probate is through joint ownership of assets. So when one owner passes away, the asset automatically transfers to the surviving owner, bypassing the probate process, right? So that's one of the most common strategies that we use. When an asset is jointly owned, upon the death of one owner, it automatically transfers to the surviving owner without the need for court intervention. This significantly can reduce legal costs, save time, and ease the burden on surviving family members during an already difficult period. Some of the pros, again, like I mentioned, it's a seamless transition. So assets such as homes, bank accounts that are held in joint tenancy automatically transfer to the surviving joint owner. Then there's no probate court, and the surviving owner has immediate access to manage that asset without waiting months or years for the court's approval, right? So however you want to make sure that real property houses are held in jointly, should be held jointly, joint tenancy with right of survivorship, not as tenants in common, because tenants in common does not avoid probate because there's no right of survivorship. So for example, family members and friends, they often choose to purchase real estate with joint tenancy with right of survivorship. Now, some of the cons to that would be that it does include some risks, right? So shared liability, what does that mean? It means that you and your co-owner have equal legal rights to the asset. If they encounter legal troubles, your jointly owned asset could be at risk. So if the co-owner files for bankruptcy, or divorce, or faces creditor lawsuits, that jointly owned asset could be targeted by creditors. This could result in liens, forced sales, or other financial entanglements that can affect your property, even if the issue has nothing to do with you. And loss of full control, right? Major decisions regarding that particular asset, like selling it or refinancing the property, typically will require the agreement of both of those owners, right? So some key considerations to consider for joint ownership is to carefully understand who it is that you're choosing to be a co-owner with, right? Ensure that that person is financially stable and trustworthy. Understanding the risk, right? Joint ownership should not be entered into lightly. It's a legal and financial partnership. So you could explore some alternatives, which I'll talk about, by using a revocable living trust or transfer on death designations, which may offer similar probate avoidance strategies with fewer risks, right? So joint ownership is a powerful estate planning tool to avoid probate, but it's essential to balance the convenience of automatic transfer with potential legal and financial risks, right? So in the right circumstances and with the right planning, it can provide an efficient and compassionate way to handle asset transitions during life's most difficult moments. Next slide. We're going to talk about beneficiary designations, including a ladybird deed, which I'm sure you have heard about, right? So a second way we can avoid probate, which is not as risky as joint ownership, would be designating beneficiaries on our assets like life insurance or retirement accounts. And you can also do this with bank accounts, right? You can go to the bank and retitle and say, I want this to be designate a beneficiary, right? So the nice thing about this strategy is that unlike joint ownership with right of survivorship, the beneficiary doesn't have any rights to the asset until you pass away. But that can be done through a payable on death or a transfer on death. But keep in mind that if they have creditors, once you pass away, it can be subject to their creditor claim. So the beneficiary designation does work very well. The cool thing is in Florida that what we have here is we can name beneficiaries on real estate property with what is called a Lady Bird deed. A Lady Bird deed is also called an enhanced life estate deed, and it allows a property owner to, number one, retain full control of that property during their life. So you can sell, you can mortgage, or you can change beneficiaries without anyone's permission. It automatically does transfer your named beneficiary and it avoids probate. And why it's so powerful is because you don't lose ownership and control while you're alive. There's no court involvement is needed after death. And it's useful in Medicaid planning and maintaining eligibility for those government benefits. So some of the pros are, again, reduces paperwork, court involvement, assures efficient and privately for those intended heirs. No executor is needed. And as you think, those as circumstances change, you can make those changes according to your circumstances or your wishes. Some of the cons about that is potential guardianship and loss of control after death. So despite its advantages, direct transfer strategies come with important drawbacks. So number one, naming a minor as a beneficiary. So minors cannot legally own financial assets. A court-appointed guardian will be required to manage that asset until the child turns 18 or until a judge says otherwise. And this process can be very costly, very time-consuming, and it may not reflect your true values. Beneficiaries with special needs or financial judgment. If the beneficiary receives government assistance, inheriting assets outright may disqualify them from benefits like SSI or Medicaid. Number two, if the person struggles with handling money management, they may waste or misuse the inheritance immediately. And in these cases, we can do special needs trusts or provide spendthrift provisions in the trust, which may be a better option. So final thoughts on this is direct asset transfer methods can offer a clean, efficient, and probate-free solution, but only when used carefully. So you have to consider who your beneficiaries are, right? You know your family and better than we do. The ability if that person to be able to manage money and legal responsibilities, and the potential for the trust structures to protect vulnerable individuals such as family members or children with special needs. Next slide. Now we'll talk about irrevocable living trust. What does that mean? A revocable living trust allows individuals to place their assets in a trust during their lifetime, which can then be distributed to their beneficiaries upon death, avoiding the need for probate entirely, right? So what is a revocable living trust? It's a legal estate planning tool that allows the individual, whom sometimes we call the grantor, to, number one, continue to manage those assets during their lifetime, and additionally then designate how those assets should be distributed upon their death. So the term revocable, it just means that it can be changed during your life. It can be updated, and you can even revoke it entirely at any time during the grantor's life, which offers flexibility and control during your life, right? So how does it work? The grantor transfers ownership of assets such as real estate, bank accounts, or investments into the trust. The grantor typically serves as what we call the trustee, which means that they're going to manage those assets as they normally would. And upon the grantor's death or incapacity, a successor trustee steps in to manage or distribute the assets according to the instructions of the trust document. What are the benefits? Number one benefit is it avoids probate completely. And there is no court involvement needed to validate a will or oversee any distribution. This is particularly such a useful tool. Another one is beneficiary designation. Assets in the trust are going to go directly to those beneficiaries by the successor trustee, again, based on the grantor's instructions. So this ensures that the grantor's instructions are clearly followed without any legal delays or any disputes. And trust can include specific conditions such as age requirements, such as spending limits, or state distributions to protect those beneficiaries, right? If I got an inheritance at 18, it would probably be gone by the time I was 19. So we can stagger those at 20, 25, 30, depending on your family structure. Additional benefits is that a trust is completely private. It's not a public document like a will. So asset distribution remains private. Incapacity planning. If the grantor becomes incapacitated, the successor trustee can manage those assets without the need for court-appointed guardianship, right? And then the trust again allows you to delay or stagger inheritance, which is very helpful for minors or those in your family who will benefit that are not financially responsible. So it allows you to retain control, avoid probate, and it ensures that your assets are going to be distributed smoothly according to your wishes. Next slide. All right, advanced directives, what are they? They are also legal documents that are going to outline an individual's preference regarding medical care and decision-making in the event of incapacity. These are essential components of comprehensive estate planning. Next one, I am going to talk about one that I'm sure you have all heard of, power of attorney. What is a power of attorney, Karen? It's a legal document, and it's designating someone that you trust completely to make financial or legal decisions on your behalf if you become incapacitated. This ensures that their affairs are going to be managed according to their wishes, right? So it becomes especially important tool if you become incapacitated, disabled, or you're unable to manage your own affairs, right? The primary purpose of this is to ensure that, again, keyword, someone that you trust can act on your behalf if you are unable to make decisions for yourself, either temporarily or permanently. This can include things such as paying your bills, managing your bank accounts, filing taxes, handling real estate, making legal or contractual decisions, right? So a well-crafted power of attorney ensures that your personal and financial affairs are handled according to your values and your wishes, even in times of crisis, right? So we know that life is unpredictable. Accidents happen, illness happens, cognitive decline can happen and can strike at any moment to anyone. So without a valid power of attorney in place, your family may be forced to go through a lengthy and costly guardianship proceedings to gain legal control over your affairs. Again, this is a very important document for estate and incapacity planning, and it helps avoid unnecessary stress, delays, financial disruption, right? So imagine a person has a stroke and becomes temporarily incapacitated. Then what do you do? If you have the power of attorney, then you can access funds to pay medical bills. You can manage investments. You can handle insurance claims. You can sign documents on their behalf, right? But because without this document, your family can be powerless to act without court intervention. Again, it's a foundational component for estate plan. It's going to protect you. It's going to protect your finances and your family by ensuring that the right person can act in your best interest when you cannot. Next slide. Designation of healthcare surrogate. A healthcare surrogate designation is going to allow individuals to appoint someone to make healthcare decisions on their behalf if they're unable to do so. This makes sure that their medical preferences are respected. Some people have religious views on transfusions or certain medical procedures. If this is not documented, then this won't happen. So this is why it's so important to have these documents. Next slide. Living wills. What is a living will? Those are going to be living wills, do not resuscitate orders. Those are going to provide clear instructions regarding end of life and medical preferences. So the living will is going to allow is a legal document also that is going to allow for the individual to make medical decisions when you cannot make those medical decisions for yourself. Choosing a surrogate. That surrogate is going to be important because, excuse me, I'm sorry, a do not resuscitate order. I lost my screen. So a do not resuscitate order is going to be a legal document that is going to say when you do not want any life-saving measures during cardiac arrest or respiratory issues, meaning, maybe I shouldn't say this, but when do you want someone to pull the plug? It doesn't necessarily happen that they just pull your plug. You have to have 2 licensed physicians in the state of Florida to say that you are either in a vegetative state, you have an end of life, you have a terminal condition, or you have an end stage condition. So these are the things that, you need to talk about with your family. Next slide. And I know that I gave you so much information. So in conclusion, estate planning isn't just about distributing assets. It's protecting your family, making sure that your children don't end up in foster care or without a guardian that can raise them in the event that you're not here. It's about preserving your family and your legacy and ensuring peace of mind to those that you leave behind, all of your loved ones, right? So without a proper plan, important decisions about your health, your finances, your property, those things that you work so hard for could be left to the courts, and which you'll hear from my panelists, often leading to unnecessary delays and added expenses and family conflict. So you need to take action today. How do you do that? You want to avoid probate. You want to minimize taxes. You want to protect your vulnerable beneficiaries and maintain control. Don't wait for a crisis to start planning. We're here to help you. Wills are not one size fit all. We have blended families. We have all kinds of families with different wishes and needs. So this, again, like I said, it's not a one size fit all. We are here to help you achieve peace of mind through thoughtful, comprehensive planning. Again, my name is Karen Skyers at Aris Law, and it has been my pleasure to be here with you this evening. Thank you.
Great. Thank you very much, Karen. Good information. We appreciate it. And remember, our attendees, that if you have any questions, type them in the Q&A box at the bottom of the screen. And we're going to get to your questions right after all our presentations. So moving right along, we're going to have another presentation. Now to give us more information about the probate process, we have attorney Lawar Jean-Pierre with JP Law and Wealth. Thank you for joining us, Lawar.
Hi, good evening, everyone. My name is Lawar Jean-Pierre. I am the managing attorney here at JP Law and Wealth Advisors. Thank you for spending your afternoon with us. Today is really going to talk about probate. My colleague did a good job explaining how to avoid probate. Now I'm going to talk about these different kinds of probate, specifically to Florida law. Next slide. So quickly about us, our firm is a unique combination. We're both a law firm and a financial firm. What does that mean? We're able to help clients invest in the stock market. And on the legal side, we specialize in estate planning. So we are not a jack of all trades and master of none, but we specialize in estate planning and probate. That is all that we do. So our goal is to help families and businesses like yourself stay out of court. Next slide. And just quickly about myself again, I have over 10 years in the financial industry. I am, I guess, trilingual, if you must say. We speak Creole, French, and Lingualese. And my colleague down south in Florida also speaks Spanish. We have an office here in Maitland, Florida, and also in Florida. Next slide. So what is probate? Again, Karen did a great job explaining what the probate process is, but essentially is the court stepping in and deciding who gets what, the simplest term to put it. If you have a will, we have to submit the will to the court for the court to determine if that will is valid. And if you don't have a will, then Florida has its own rule, what's called intestacy law, that is going to go ahead and use to distribute your assets. So I like to remind clients, even if you didn't make a plan, the state has a plan for you. It may not be the one that you like, but there is a plan in place if you do not have a will that the court is going to go ahead and follow to distribute your asset. So essentially, in simple term, probate is the court process of the judge determining who gets what. And we'll go a little bit more on the next slide on how the different kinds of probate based on your assets. So the formal administration, think of it as when someone has an estate over $75,000 or more. So if, for example, your father, mother, whoever it is has passed away and they have a 401k account that had no beneficiaries in it and it's over $75,000, well, we have to go to probate court. And more likely than not, you'd have to file a formal administration. And that is because their estate, meaning things that have to go to probate, was over $75,000. Is going to require someone to be named as a PR, a personal representative. So sometimes we think our home, if our home is exempt, for example, that may not count towards that. And I believe my colleague will talk more about the procedures of the court. But as far as the estate itself, anytime that you have an estate that is worth more than $75,000, thinking of everything that is in your family's estate that passed away, we have to file a formal administration. And that process takes a bit longer than typically, right, give or take, depending on the court and the different requirements, can take about 8 months to years to settle because we have certain steps and certain requirements that we have to follow. The next option is summary administration. This one's a little bit more simplified. It's as if everything else in the estate, again, that example of, let's say you had an account somewhere and you only had $5,000 in it or $10,000 and you have a car and everything else, but combined, it's less than $75,000. That is a summary administration. It's typically faster than a formal administration because we have less things to deal with and the process is a little bit easier. Doesn't mean it's not a stressful process for you as the individual going through it, but it is a simpler process because we have less assets to deal with. So a summary administration is one that everything in the estate, besides your exempt property, such as your homestead, is $75,000 or less. Then we'll have a summary administration. Then we have the third option as well, which is the disposition without administration, meaning it's a very small estate. Let's say you had an account somewhere, maybe you had $500 in it, and you had to go ahead and pay for the funeral expenses. You can yourself request for the court to do a disposition without administration. That is the most simplest process and doesn't require too much of paperwork and cost because the estate really doesn't have much to give out. So that one is a very streamlined process and very short process that a lot of people fall into and try to go through the clerk and get guidance from them, and they can give you proper guidance and documents on how to go ahead and deal with that part. But the formal administration, that is one that you will require an attorney to help you through that because probate, it is a very stressful process, but there are steps that we have to follow to make sure things are done properly. So disposition without administration is one that a lot of people will do by themselves, just going to the clerk of courts and having the proper documents and following their instructions properly to submit. So these are the top 3 kinds of probate, essentially in Florida. Go to the next one. And we have ancillary administration. So what does that mean? Let's say that you are a resident here in Florida, but you had a property elsewhere, let's say Georgia or Texas. Well, or the person passed away in Georgia and Texas and they had property here in Florida. So they have to go ahead and request for the court to deal with the property that is here in Florida because when you pass away, wherever that property is located, the law of that state or that county controls. So if you, let's say you were a resident of Texas and you passed away, but you had a home here in Orlando, you'd have to reach out to an attorney here to help you do an ancillary probate. Essentially saying you're a non-resident, but you have property here in Florida, we have to account for. So that is the one that is not as common as the other 3 that we mentioned, but it is still something that is available for people that have properties here in the state of Florida that passed away in a different state. And again, it's the same process requiring certain documents, certain steps to be done properly so that we can distribute the assets accordingly. Because again, probate is a process of the court determining who gets what. So if your property is here, even if you did have a will, you still have to submit it to the court for the courts to say, okay, this is valid. And these are the beneficiaries that we are going to go ahead and distribute it to. Next slide. So the court process, and Karen did a good job of already going over that, but there are certain steps that we have to follow when we're filling out probate, especially if there is a will in place. we have to submit the will for the court. And if there isn't a will in place, we have other documents that we have to go ahead and submit. Either way, whether you have a will or not, we'll have someone called the personal representative. That is the person, or also known as the executor, that is going to handle the estate. A lot of us have probably heard of, I'm the executor of my mom's estate. What that means is that you were assigned by the court and had that letter that says you are the PR. So what does that mean for you? Let's say, for example, you have a bank account that the bank is not willing to speak to you about what's in the account because legally they don't know who are the beneficiaries. Well, by being assigned the personal representative, also known as the executor, you're able to go with that letter to the bank and say, here, I am named the executor of the estate. Then they can go ahead and divulge information to you legally to say, okay, this is what's in the account. These are the accounts that the decedent had and how to move forward. But you cannot do so unless you go through the court process. And I'm sure everyone here has, gone through the horror stories of having to do probate, but the banks have their own guidelines that they have to honor. So unless you are listed as the personal representative, again, aka the executor, they cannot speak to you regarding certain assets. So that is one of the major parts of probate, being able to be named the person that handles the administration. And again, a simple probate, like we mentioned, the summary can be as simple as 3 to 6 months or longer, because every county and every state have their own rules and different checklists to go by. And there are so many things that can come up, especially as creditors. We have a creditor's period that we have to go through. Again, Florida is 90 days. So imagine someone had passed away and we have to abide by the creditor's period. That is 90 days that we have to stay still. So if your loved one had an account that you need to go ahead and pay a mortgage in, or whatever the case may be, but they had no beneficiaries listed, we cannot access that account until we are done with that process. And just starting off, we have a 90-day period that is a creditor's period that we have to abide by. So that is very important. As my colleague mentioned, avoiding probate is 100% avoidable, right? It is 100% avoidable, but we have to take the steps to make sure that it is done properly. But again, part of the probate process is being assigned as a personal representative. And we have a specific step that go through that so that you're assigned and that you're able to now speak on behalf of the estate and handle the estate accordingly. Next slide. So why avoid probate? Again, I think we all here have either have gone through it ourselves or have heard the horror stories. It is a slow process. It's not a one and done process where you just file the documents and the court decides to go ahead and give your stamp of approval and it's done. It is a very slow process and it's also costly. It can go up from $3,000 or more to 3% of the estate. And most attorneys, sometimes they charge an hourly rate and that can run you from $350 or more hourly. So it's not only about the cost I want to mention, but it's also about the stress, the emotional cost. I like to tell my clients, your family cannot grieve properly until the legal process is done. As they are going through the legal process of dealing with the creditors, of dealing with everything else, or maybe someone fighting over the estate, they cannot grieve you properly because they're dealing with the legal process. So the cost part is not just about money, but it's the emotional and stressful part of it. And also it evades privacy. Because again, if you think about it, the will, it is part of the public record. The distribution that the judge is going to sign the final order part is part of the public record. So anyone, that can have access can see who are your beneficiaries and who got what, right? So again, who gets what? That's what probate does. So it really evades your privacy and put it all out there for anyone to see that, this is your beneficiaries and what you had in your estate. And again, the stressful part. What your legacy should be is not leaving a problem to your family, but really allowing them to be able to grieve you properly and be able to handle your estate without court involvement. So as we mentioned, probate is not only a mental stress, but a financial stress. So those are the main top reasons to avoid probate. But really it's about who do you care about and who you love to make sure that they are staying out of court. Next. So how to avoid probate? Again, we already kind of mentioned that, but the three easiest way to avoid probate is making sure, the number one is making sure you have an adult beneficiary. That is easy and free to do. Having an adult beneficiary on your financial accounts. Most financial institutions, they allow you to do that online. You don't even have to go in person to do so. And if it's an adult beneficiary, again, like my colleague mentioned, you would not have to go through the court system and be assigned a legal guardian. So for those who have adult children and they already have made up their mind about who they want to be beneficiaries, that is the easy and free way to do so. You don't even need an attorney to do so. You go online and you update your beneficiaries, and that is it. Upon your passing, they go to the bank, provide your death certificate and their ID, and it's an easy process. And my colleague also mentioned having joint accounts of right survivorship on accounts, whether it's a property or a bank account. That avoids probate. Using a Lady Bird deed, an enhanced life estate deed, and of course using a trust. And most importantly, that is properly funded. As attorneys, we talk about having a trust and making sure you avoid probate, but doing the trust is the legal part. I always, encourage my clients in part of our process in making sure the trust is funded. If you set up a trust, you did the legal part, but you never actually put the account and the name of the trust or added the trust as a beneficiary, you have done absolutely nothing but waste time and money. So for the trust to properly avoid probate, it has to be properly funded or be the beneficiary of those accounts to avoid probate. Because anything that is left in your name alone, in that person's name alone, upon their passing, has to go to probate. And one of the biggest misconceptions is that for a married couple is that if I am married and my husband has an account, then it should automatically go to me. That is not the case. Just because you're married does not mean the account goes to you, because you had to have been either a joint owner or listed as a beneficiary. So again, those are 3 things. One of them being free, that you can do right now as we're on the call, because some accounts allow you to do online, to make sure you have an adult beneficiary as on all of your financial accounts. And as far as real estate properties, getting from an attorney to make sure you're either using a Lady Bird deed or using a trust to transfer the asset to your loved ones, and making sure they are staying out of court. Next. And this is just a joke, right? To say probate is not fun. You just kind of hang on and you're at the mercy of the court and the mercy of how things are going, how fast things are going. If, the judge's docket is full, it's based on how fast things are going through. It's not a specific timeline that you file probate today and in 3 days you're guaranteed a final order. It has to go through its process. So it is a very lengthy process and you're at the mercy of the court. And again, if we can avoid it, which is 100% avoidable, probate is 100% avoidable if you set up things properly and take the time to do it on behalf of your family. Next. Okay, so as my colleague mentioned, we're going to go ahead and answer the questions at the end of the seminar. But I did go ahead and have our information here. You can go ahead and scan. We are offering for everyone that attended here, if you would like, a free 15-minute consultation. So feel free to scan that and we'll be happy to speak with you directly.
Great. Thank you, Lawar. Attorney Lawar Jean-Pierre. One of the questions and one of the items I wanted to address actually is we were asked about slide decks, if we could provide those. The easiest way for everybody attending this to take a look at the different slides is to go back to our recordings. This is being recorded. It will be shared on our website at the Orange County Clerk of Courts and also on our Facebook page for the Orange County Clerk of Courts. And that would be the easiest way to go back and take a look at the presentations. Okay, so great information. Up next, now in our forum, is our Probate and Mental Health Operations Manager, Michael San Giorgio, who's going to share with us the Clerk's Office probate filing process. Michael.
Thank you, Dane. Good evening, everyone. Like Dane mentioned, I am Michael San Giorgio. I am the Operations Manager here at the Orange County Clerk of Courts. And this evening, I will be discussing the probate filing process. Next slide, please. First off, a brief description of the clerk's role within the probate process. It all begins with the intaking of case filings. These case filings can come to us either at our front counter or via e-portal, but they come in, and the first thing we do is we verify that the necessary documents and information has been filed. When that's all settled, we go ahead and update and maintain the court file. From there are instances throughout the probate proceedings where you may need certified copies. You can come to room 335, which is the probate division, and we could provide you them there. Or in room 150, it's the records management division. They also can supply you with the certified copies there. And finally, in some instances, summons and notices for appearance need to be issued, and we take care of that in room 335. Next slide, please. Okay, so how to file case documents. It's different for attorneys and pro se filers. Pro se filers are simply those individuals who are not represented by an attorney. Attorneys must file all pleadings through ePortal. They also must submit proposed orders directly to the judge, while pro se filers may file pleadings through ePortal or in person in room 335 at the downtown courthouse, or via mail with the mailing address listed in the slide. Additionally, pro se filers must submit proposed orders to the clerk's office. Now, everyone must file the physical will and exemplified copies either in person or by mail, and that's simply because these two documents, we need the physical copy for authentication. Next slide, please. Okay, so this slide provides a list of the majority of the different case types and pleadings within the probate division. The previous presenters have gone over the first three. I'll provide a little bit different information on them. And then really the remaining portion of my presentation will go into the various petitions and pleadings. Okay, first up is the formal administration, which really is the most common, at least what we see in our office. And the main thing to remember here is that a formal administration must be filed by an attorney. When to file a formal administration is when the value of the estate exceeds $75,000 and the person has been deceased for less than 2 years. Now, there is a particular instance where an attorney doesn't have to file a formal administration, and that's where the personal representative is the sole beneficiary. However, just because a personal representative is listed in the will as the deceased person's preferred person to be the personal representative, that is not a guarantee, and the court needs to be petitioned. So you may choose to hire an attorney to assist you in the filing to determine who the personal representative is. And with the filing of a petition for formal administration, you must also include a proposed order. The next most common type of administration is summary administration. This is where the estate's value is $75,000 or less, or the person has been deceased for more than 2 years, regardless of the estate value. We have petition for summary administration packets here at our office that can be purchased for $5. You need to include, though, a copy of the funeral bill if the person has been deceased for less than 2 years. Now, within the petition that we provide here, the proposed order is included. However, if you were just to provide your own petition, it is important to include that proposed order. Next up is the disposition of personal property without administration. And for this one, you're thinking smaller estates. As the previous presenter mentioned, it's usually under $6,000. But when to file is where the deceased person did not own any real estate and the only assets left behind are either exempt personal property or non-exempt personal property that is equal to or less than the funeral and medical expenses paid by the person requesting the reimbursement. Now, if you have questions as to what exactly is exempt personal property, Florida statute 732.402 goes and defines what consists of exempt personal property. Some common examples of qualifying assets include bank accounts with small balances, refund checks from either the Social Security office or insurance, final paychecks, life insurance that is payable to the estate, small tangible property, and it could be a vehicle. A little bit more about disposition of personal property without administration. What must be filed is the verified statement for disposition of personal property without administration and a completed consent to disposition of personal property form. Now, we have both of those forms available on our website at myorangeclerk.com under the Forms tab. They're actually the same document, so you just need to open the one and they're back to back. You also must file the original will, where there is one, and copies of the funeral bill, or receipt showing funeral expenses have been paid, a copy of the death certificate, and a copy of the asset. Examples of that being a copy of the bank statement, copy of insurance policy, stock certificate, check, vehicle registration, and the Kelly Blue Book value. Next slide, please. There we go. Thank you. Okay, so the next two things are wills for safekeeping and petition to open a safety deposit box. Wills for safekeeping, typically this is done to prevent loss, destruction, or tampering of the original will. Important to note here that these can only be filed after the person has been deceased. They can be deposited with the clerk's office for safekeeping. Now, this does not begin a probate case. It just files the will with our office, and there is no filing fee. The petition to open a safety deposit box it allows a court-authorized person to open a safety deposit box prior to the probate being officially started. This is used when the petitioner believes the will or other important documents are inside the safety deposit box. Who can file? A spouse, adult child, or someone who reasonably expects to be named in the will. We have this petition available at our front counter in room 335 for $5, and the proposed order is part of that. But again, if you file your own petition, it is important to include the proposed order. Okay. Next up is notice of trust and caveat, which are similar but have important differences. For the notice of trust, it informs the court and potential creditors that the decedent had a trust at the time of their death. This must be filed by the trustee of the decedent's trust, and we often see that trustee accompanied by the assistance of an attorney. A caveat informs the court that someone wants to be notified before a probate administration is open. Basically, this is a way of saying, don't begin the probate process without giving me a chance to be heard. Sometimes they may want to provide their input related to the appointment of a personal representative. So here, the caveat must identify the caveator and the decedent. It must provide the caveator's interest in the estate and request for notification, and it must be signed and verified by a notary. Okay, we'll round out the presentation with a few petitions that we see in our office. The first one being a petition to amend death certificate. This requests to correct or change information on a decedent's official death certificate. For whatever reason, the most common reason we see this is that the marital status on the death certificate is wrong. But it could really be any information on the death certificate that is inaccurate, and we do see this. What you'll need is the death certificate and usually documentation proving why it should be changed. And again, this is one of those instances where you need to file a proposed order. Petition to admit foreign will. This requests that a will executed outside of the state of Florida be recognized and admitted to probate within Florida. Now here you'll need to file an exemplified copy of the will and a proposed order. Often that exemplified copy will come from the clerk's office where the will originated. Petition to determine homestead status of real property. This confirms the property is a homestead, it identifies legal heirs, and excludes the home from the probate assets. And this, again, is something that can be filed prior to the beginning of the probate and can help assist in the direction which type of administration to choose. We do have the petition here at our front counter for $5, and this is another instance where the proposed order is necessary. Finally, there is a few ways to contact us if you have any questions. The first being our website, myorangeclerk.com. You can click on the Contact Us tab at the top, scroll down to Probate, and select our division, which will take you to this screen where you could fill out the necessary information. We have a turnaround time of 48 hours. However, we normally get back to you within about a day. Additionally, you can contact us at 407-836-2000, option 6. Our probate division experts answer your phone calls. We answer the phones between 8 a.m. and 12 p.m. And we hope to hear from you. Like I said, my name is Michael San Giorgio. You might also be assisted by my assistant manager, Jessica Stagnolia, and I appreciate you attending this. Thank you.
Yes, great. Thank you, Michael. And that is Michael San Giorgio, our operations manager for our probate mental health division. Michael, don't go too far because I do have a question during your presentation that I want to get to directly from you. The question was, if I have already done my estate docs, is there a way to check them, quality check them to make sure they'd be approved by your department?
I would say not necessarily. However, you can absolutely come into room 335, and while we cannot provide you legal advice, we can walk through the document with you to ensure that it does have all the necessary information.
Okay, great. And that is at the Orange County Courthouse for the suite for probate, downtown Orlando on Orange Avenue. For those of you who are just joining us, welcome to our legal forum on probate, wills, trusts, and estate planning. It's a recorded webinar. And again, if you have any questions, you can enter them in the Q&A function at the bottom of your screen. We have one more presentation to get to before we'll get to all the rest of the questions and try to answer all those questions. So up next, I have the pleasure to introduce the Honorable Judge Mike Murphy, who's taking time to share with us a perspective from the bench. Thank you for joining us, Judge Murphy.
All right, thank you very much. As you just heard, my name is Mike Murphy. I've been a judge since 2005, and I'm starting my third year of probate and guardianship division here in Orange County. I did 3 years earlier in Osceola County, still part of the Ninth Judicial Circuit. Here in Orange County, we have 3 judges that do probate and guardianship. And just to give you a perspective of numbers of cases, in February, 580 cases came in the probate guardianship. 504 were resolved. January, 486 came in, 474 resolved. In December, 459 came in, and 511 were resolved. In my personal division, I have 751 open formal administration cases and 150 open summary administration cases. Now, even though I have a bunch of cases, I want to tell you that if you are involved in a probate case, it is rarely a good thing that you actually have to personally see or come in front of a judge. The process is actually designed to never see a judge if everything is done properly. Yes, the judge is involved. We sign orders. That's true. But there is no legal requirement to actually have to come in front of a judge to address your case. In fact, I think most judges would say that they're happy when the case is resolved without having to ever see us in person or virtually, so that we could spend more time, we the judges, could spend more time on the very complicated cases where people have probably either not hired a lawyer to do their will, don't have a will. And so, and we do have, I would say about 80% of the cases are resolved with just paperwork only. There's probably about 5% of the cases that are resolved with minor court appearances. And then that leaves about 15%, and maybe a little bit less, of actually full out, knockout, drag out contested cases. Now, as you heard, although there's a super small exception, a lawyer is required to represent a personal representative. And the small exception is so small, it's pointless to talk about because it almost never occurs, especially at the beginning of a case. But when it comes to summary administration, a lawyer is not required, although from the judge's perspective, the lawyers make it move more smoothly. Now, lawyers practice all over the state, and every circuit is different, and every judge within the circuit is very different about what we want. Although it's fair to say we probably all think we're doing it most correctly and most efficiently. Now, to help lawyers and even pro se people, we have checklists to do nearly everything. But of course, lawyers and pro se people, even with a checklist, still have issues. And our checklists that we use are located on the Ninth Judicial Circuit website. And there's a checklist for opening an estate, a checklist for summary administration, a checklist for a petition to determine the homestead status of a case, and for closing the administration. Of course, these checklists are in addition to deadlines that are imposed by the Florida Supreme Court or the Florida legislature in the statute. But the checklist, if properly followed by the lawyer or the pro se person, when the pro se person is, say, doing the summary administration, it should actually cause the case to be very seamlessly resolved. But don't worry, even if you make a mistake when doing the checklist, most of the time what will happen is the judge will sign an order that will say denied without prejudice for you to fix the problem. And if you fix the problem the next time, then likely the order is going to get signed. If you don't fix the problem, likely there'll be another order denying it. And if you can't fix it at that point in time, the judge is likely to have to bring you in so that it can be discussed, because apparently the language that's coming from the judge is not being understood by the litigant, and what the litigant is saying is obviously not being understood by the judge. Sometimes it takes about 30 seconds for the judge and the person to be on the same page, and the next time, problem solved. I'm not beyond any error, and I've had people come before me and they said, Judge, it's right there. It's just titled something different than you were looking for, and I'm embarrassed, and I signed the order right there. So it's not always the litigant's fault. Sometimes it is the judge's fault. Now, to give you an idea of the process of what happens, say you file your petition for summary administration. Once that petition is given to my judicial assistant, along with a proposed order, and please, if you're a pro se litigant, please type it. I can retype language. Sometimes handwritten is impossible. And plus, if you have a handwritten order that you, even if I sign it and you take it to a bank and they can't read the account numbers, you're not going to get much accomplished. So please, if you can, I know not everyone has the ability to type, but do your best if you want it to be understood clearly and be interpreted clearly by people who get the orders. All right, so let's say it's denied, and let's say it goes to the court. It's very important that you understand that court proceedings are not electronically recorded by the court reporter. You are responsible to, or maybe there's another side, responsible if you want it to be recorded in case you want to appeal the judge. And judges definitely are not infallible. We are routinely reversed around the state for making a decision that's wrong. I don't, not just probate in every division. But if you want to have a chance to reverse the judge, you need to have hired a court reporter and have the court reporter with you at the hearing. And the hearings sometimes are virtual and sometimes they're in person. Most of the time, the virtual hearings involve cases in which there's no evidence being presented. It's just about argument, discussion. If there's evidence that's going to be presented to the court, documents or witness testimony, evidence, those are where the judge prefers those most of the time to take place in the courtroom. So we know that the person is providing testimony without having like another computer monitor over here, a person behind them, where they're not showing up in this artificial screen behind me. So when they're in court, we know that they're getting, we know what's in front of them and that they're not getting help. So we prefer those in court. There are times where people don't live locally, and there's a process where people can be allowed to virtually appear, but we put safeguards in place to try to prevent the risk that someone might be looking at things they're not supposed to be, or not being pressured to say anything by someone that's just off the screen from them. The next thing I want you all to understand is courts have an obligation to follow the law. And I know sometimes that's frustrating to people when following the law results in a different result than probably what the decedent wanted. Now, this is rarely ever a problem when people have lawyers that are involved in making the wills. But let's say you make a will yourself, and let's say the will you do only has one witness to the will that's signed. That it doesn't matter that the person in that will said, I want everything to go to person A. If the will isn't valid under Florida law, the judge has to say the will is not valid, and that likely will result, unless there's some other will that existed prior or intested succession that still gave it to that person A, it likely would result in person A not getting that property. And I know that's frustrating for, especially in my example, person A. But it's also frustrating, although judges are required to law, we understand the frustration. So therefore, it's very important that every person that's hearing this, if you don't have a will, that you do a will. Even if you don't have any assets, you might get some assets tomorrow, and you want the money or assets to go where you want it to go. I also suggest that if you're going to exclude a child, and we have that all the time, you have two children, for whatever reason, you want to give everything to child one and nothing to child B. If you want to avoid that to be a long litigated probate action, it's best to tell person B why it is that you're not going to give the items to person B, so that there is no surprise. Another thing, if you get married, redo the will. There's ramifications for not doing a will after you get remarried. If you have a child or adopt a child, redo the will. There are ramifications if you don't redo the will. While you don't have to redo a will if you get a divorce, because there's some presumptions that happen, it's still a better idea to redo the will. Now, prior to this hearing, or prior to this presentation, I asked ChatGPT to ask me some questions of what I should be expected to hear. So I'm just going to include them since I know I'm less than 20 minutes. Let's see, what's the most common mistake that delays the closing of an estate? It's typically because the people are not presenting the information that the judges need to see in a clear way. But even with those checklists, sometimes, for example, I've like a checklist in front of me now, and one of the things is it signed by the petitioner? For sometimes people will write there the date they thought it was signed by the petitioner, but the judge looks at the document and it's not signed by the petitioner. So that delay causes the judge says denied, it goes out. So I mentioned earlier, the clerk does an audit. They look for things like, is the death certificate there? If the death certificate isn't there, the clerk alerts the court. The court does an order that says denied death certificate. So the failure to include the death certificate could be a denial. But if people follow the checklist, we usually in this circuit have a really quick turnaround, less than 2 weeks from that anything being filed. It should already have been signed by the judge and copies given to everyone. Next, it's very important that if you're a pro se, and I would do this too if I was a beneficiary in a case, I'd make sure it's on the e-service, so I got a copy of everything that's being filed in the case. That requires you to give your email address to the clerk of the court. And if you're a party, you're required to give it. Well, if you're basically a pro se litigant, you're required, unless you opt out, to give your email address to the clerk. But that's one way to make sure you're always getting your information timely. The next question says, have I noticed an increase in self-represented parties in probate court? And if so, what advice would you give them to better navigate the process? Well, we don't see pro se people when they're personal representatives, because the personal representatives have to be represented by a lawyer. But in summary administration, all the time we get pro se people. Follow the checklist, do your documents, make sure they have all the information required in the checklist, and that's a good start. What do you look for in a well-prepared petition or motion that makes it easier for you to rule efficiently? Well, let's start with what I said before. Typed, please, typed. Then I'll be able to read it and know exactly what you want. If you're asking for something, tell me why you think you should get it. Is there a rule? Is there a statute? Is there some case out there that you're aware of that makes you think that you deserve it? If you are the child of a person, you're receiving things because you're the child through intested succession, file the birth certificate to prove you are actually the child. People's names might be different. People's name might be the same, but that doesn't mean you're legally the child. File the paperwork, make sure it's there. Are there particular types of probate that I see more often that are challenged more? There are challenges in formal administration. There are challenges in summary administration. As a judge, I enjoy the mental gymnastics involved in the court proceedings. It makes my job interesting. It gives me great stories to tell friends and families when they ask me what's happening in court when I see the friends and families on holidays. But there's as many in both. There are probably more significant fights in formal administration because you already heard those involve assets of more than $75,000, unless sometimes you get the summary administration just because the person has been deceased for more than 2 years. But most of the time, it's the formal administration where it's the most hotly contested. Are there any benefits to the shift towards e-filing and virtual hearings? Absolutely. There are some of these virtual hearings that last less than 5 minutes. I cannot even imagine how hard it was back in the days when people would have to get up, drive all the way to court, even in a different county, out another state, for a 5-minute hearing. I can't believe how frustrating that would be. Virtually has solved that problem. Let's see. And then e-filing, as I said before, if you provide your email address to the clerk, you're going to get the orders as soon as they're entered. And that solves a lot of problems because other people might not have even, it takes one party might get it on day 2. The other party might not have got it day 4 when it was back in the days of mailing orders. And that would be an unfair advantage to one side that was getting it a couple days earlier, especially if there was time to appeal that was important. So those are the advantages of as we've progressed in time with allowing virtual hearings and e-filing. I know I'm early, and I see there's a number of questions, and I look forward to using the rest of the time for you all to be able to ask your questions. And I really hope people do go back and watch this because you all have been provided with incredible amounts of information, but in such short period of time. Hopefully, if you watch the video again, you're going to get a lot more out of it, even if you, I'll just stop with that. You'll get a lot out of it. I've gotten a lot out of it. Thank you.
Thank you, Judge Murphy. Thank you for sharing your insight with us. So yes, we do have a lot of questions that have come in. So this portion of the webinar, we're going to be answering your questions or trying to that you've sent in. And if you have any other questions, Q&A button at the bottom of the screen should be the way you'll be able to submit your question. So this first question is definitely a legal question for one of our attorneys. I'll try to summarize this. It's related to the paperwork of petition for summary administration and petition to determine homestead status of real property. So our attendee says, my father owns a property, legally says it's owned by 50% him, 50% his mother. His mother died over a decade ago. Her will and testament states everything she owns goes to the father after her husband who died before her. Small inquiry is that on her will and testament, everywhere the father's name was written as the letter L for a middle initial. Father's name never had a middle name or used a middle initial. So, probate representative was not sure how to answer, how to write it in on those 2 document packets. So, anybody have a possible answer towards that one? That's a tricky one. How that should be written in with the middle initial being on the will and testament of L, and then the father not having the initial L. Any of our attorneys can kind of indulge us on that question? Karen or Lavore?
Hey, if no one answers it, just write it what the will says.
Yeah, that was going to be my advice, to write as the will states it, and you can provide an ID and sometimes also an affidavit to explain, because I find that a lot of times if you have an affidavit that is signed and that has the evidence and document that shows, that helps a lot as well, so that the judge can see, okay, this is why the mistake is there, this is the evidence of everything else. That helps a lot.
Okay, great. All right, thank you for your assistance with that. Next question. Me and my mother bought a house together. If one of us dies, is it automatically passed to the other?
It's going to depend on how the deed is written. This is Karen. So you would have to look at it and see how it's titled. If it says joint owners with right of survivorship, then it passes. And if it says something else, then it has to go through probate.
Okay. Great. This next question, I don't know if I understand it, may have been a typo. Does TX to trust lose Save Our Homes credit?
No, the answer is you do not lose the Save Our Homes credit. You do get to keep.
Okay. All right. Next question. Is the 3% estate fee to the attorney include non-liquid assets or just some of all bank accounts, investments, etc.?
The 3% is going to go to include any probatable assets. That's the charge. 3% would be to any bank, investments, real estate. So any probatable assets get the 3% fee.
And there's a second part to that question. How would I tell if my wife and I are
joint tenants with right of survivorship on the house? You would have to look at the deed and see. Oh, sorry. It should be automatic, right? If you're married, it's going to be automatic. It's going to be what is called tenancy by the entirety, which operates the same as joint survivorship rights. As a married couple, it's called tenants by the entirety.
okay? Again, if you're just joined us, perhaps on our webinar here, you can type your questions in at the bottom of the screen, and we still have about 21 so far to go. All right, so moving on. How much is a good price for a package of documents that includes a revocable trust and all the other docs mentioned?
That's going to depend on the complexity of the estate. You can expect to start paying somewhere around $2,500 and above.
Well, thank you for that. Next question. If you do a trust, can you still have homestead?
Yes. Yes.
All right. Simple answer there. Yes. Is an irrevocable trust different from a will?
Yes. Trust will be a trust, and the will is more so a probated matter, so it has to submit to the court. Whereas a trust is an irrevocable trust, just a different kind of trust, but it is completely different.
Okay, thank you. Next question, is there a time frame to file for probate? My grandmother passed in January 25, and I have been trying to come up with funds to do it.
My recommendation would be to do it as soon as possible, because actually the longer you wait, the harder it could be, because the family can start dying, and then you're going to have to open up a probate within another probate. And if taxes are not being paid, then you can possibly lose the home. So yeah, I would say sooner rather than later.
Okay.
The only thing I want to add to that is there is a requirement that within 10 days of the person passing, that if you're holding on to the will, that you have to file the will in the county of the county where the decedent resided in at the time of her death. Or his death. So if he was a resident of Orange County and he passed away and you're holding on to the will, even if you're not starting probate, there's still a requirement that you file with the clerk of the court within the 10 days, that will.
Okay, thank you, Judge. All right, please explain how the power of attorney can be changed when a person has been diagnosed with early stage of dementia, if possible.
I would say that incapacity doesn't change the status of the power of attorney, but you can't make any changes once the person is incapacitated.
Yes. So there's
Otherwise, that's when you would run into a guardianship, then the guardianship would be required. But if the person has already done the power of attorney and then they're found incapacitated, incapacity doesn't change the actual legal status of the power of attorney.
Okay, thank you.
I will say this, that I have seen in court, I'm not giving you any legal advice, but I have seen in court where on early stages, a person has gone to a doctor and got a doctor to say that the person still had the capacity to make a change. And then they made a change to the power of attorney. Now, it might get litigated later, but at least they had in that case, they had a opportunity to have a doctor specifically say, this person today still has the ability to make that change. And I've seen other cases where doctors have said, this person today no longer has that ability to make the change. So you might still have options, but talk to a lawyer, talk to doctor.
Okay, great. Thank you. Next question. If you have a Lady Bird deed for your property and payable on death on all financial accounts, is probate still required?
It may be so, because if you have a will, for example, that says where the car goes, so it depends. The financial accounts and as far as the property itself would not go to probate, but anything left as far as, maybe it's a vehicle and you do have a will, the will still has to be submitted to probate. But at least those assets will avoid probate. Your home that has a Lady Bird deed and your financial accounts would avoid probate.
All right, great. Thank you. Next question. If a will is notarized, but one of the witness names is unreadable, is the will invalid?
Not necessarily, because when we have a will, we have what we call the self-proving affidavit that essentially says the witnesses have been notarized their signature as well. So with every will, we have to submit to the court, and the court has to review it. But just because the name is unreadable does not make it invalid, because it has to make sure that other prongs are checked off as being valid as well.
Okay. All right. Next question. So first of all, I want to say we had many thanks to Clerk Russell for putting this together, and thanks to our presenters for excellent information. We've had several attendees share how this has been very helpful. So we've got several questions from this attendee. Can a minor be a joint owner? Lady Bird transfers real property. How do you transfer personal property? Well, that's the second question, but can a minor be a joint owner?
I'll
Sure.
go with that one. So I definitely would not recommend it. If a minor gets anything over $15,000, they're going to need a guardian for their property. And even if their parents are alive, because the parents are guardians over their person, not the property. So I would not recommend that.
Gotcha. Next part, Lady Bird transfers real property, but how do you transfer personal property, furniture, clothing, jewelry, tools, etc.?
With the will.
The will. Yep. If a minor is a beneficiary, does he need a court-appointed guardian if his parents are alive?
Same answer as can a minor be a joint owner?
Yes. Is a power of attorney needed if the spouse is alive?
Yes, because the spouse can be incapacitated at some point.
Okay, yep. If one dies intested, do all assets automatically transfer to the surviving spouse?
Not necessarily. It depends on how the asset is titled.
And can a person named in the will also serve as the PR or executor?
Yes.
Okay. Next question. If my wife and I are both listed on our mortgage, will our home automatically go to her upon my death, or do we need to have additional paperwork like a trust?
It's going to depend on what the deed says and not the mortgage. So you have to look at the deed and see how it's titled.
Okay. Next question. If the estate has a wrongful death case being handled by a law firm, does the settlement or verdict go through probate law firm and subject to 3% fee, or does the wrongful death money avoid probate and handled by the wrongful death attorney?
So for the wrongful death, it has to be handled by a separate attorney to be assigned as far as the personal representative, because that's probate, whereas a wrongful death is more of a civil lawsuit. So most, especially for a Miami-Dade, for example, you have to first be assigned the personal representative to actually bring forward the wrongful death claim. So you'll probably be handling with two different attorneys, one handling the probate and one handling the personal injury, unless they do both. But essentially, you have to be assigned the PR to bring forth the wrongful death case. And once you're assigned, they can go ahead and put the 3% against the probate matter, those funds.
Okay, great. Still many more questions to go here. Next one, if I have a revocable trust, do I need a will?
Yes, with a trust, we come with what we call a pour-over will, and essentially the best way to explain is more so of a catch-all. Because as I mentioned, the trust, the way that it avoids probate is making sure you actually fund the trust properly. But if you do not have the trust funded, the will essentially serve as a catch-all to go through probate and still explain your wishes.
Okay. Next question, also related to revocable trust. If you need to file a revocable trust with the court, if not, where is it kept? Or do you need to file it with the court? If not, where is it kept?
No, the most, I guess, benefit of a trust is that it is completely private in comparison of a will. You never have to file it. You just will keep it somewhere safe. I would not recommend a safe deposit box, because if you have it in a safe deposit box, something happens to you, then we'll probably still end up in probate, because now we have to have someone assigned to go into that. So somewhere safe, preferably at home, maybe a fireproof and waterproof safe.
Okay. And what does it mean that a trust must be properly funded?
Yeah, so I keep saying that, meaning that the trust has to own the properties either in its name or have the trust be the beneficiary to that property. So for example, if you have a bank account and it's just in your name alone and you have a trust, but you're not going through the process of actually naming the trust as either the beneficiary or the owner of that account, then that account will end up going to probate. So properly funded, meaning that the trust is either the owner of that asset or the beneficiary or interest of that asset, so that it actually can control it and avoid probate.
And if I can just add a little bit to that, you want to think about the trust as a little box, right? There's nothing in that box until you actually put something in it. So that is what it means to have something funded, the trust funded, put something in it. And as Leroy said, you have to retitle your assets to go into the trust.
Okay, great. Next question. This was for a previous presenter. What does it mean to have funded trust? I think it's the same question, right? Yeah. All right. Does a spouse have right to survivorship of all joint accounts and all jointly owned property in the state of Florida and does not require probate?
Typically, I would say yes.
Okay. Next question, is it required to have an attorney to execute a will?
Well, it's not required, but it is highly recommended. And I'll tell you, because the do-it-yourself wills end up in nightmarish situations we have a lot of bad things happen with do-it-yourself wills. I think you should leave that to the experts.
Okay. If an estate has a wrongful death case keeping the probate open, can a home be sold before probate closes?
No, it cannot be, because you have to have the final order to be able to sell that property.
Okay, thank you for that. Again, if you still have questions, you can enter them, type them in Q&A section at the bottom of the screen. We still have more to go. Next one, what is intestate succession?
Intestate succession means that you die without a will. So in any state that you pass away or have property, that state has laws that say, if you did not make a plan for yourself, we have a plan for you. In the state of Florida, what it means would be, if I were to pass away, the next thing would be, do I have a husband? Do I have a spouse? Do I have children? And if I don't have children, then do I have parents, siblings? And then it goes down the line. So that's the intestate succession.
Okay, great, thank you. Next question, if I have remarried and now purchase a new home with my current husband, if I pass away, can I leave my portion of the home to my child from previous marriage?
Yes, and some laws, if you do not have a will, it'll sometimes actually will default to that because you do not have children in common. So the law will kind of cover for the children that are in common. So that sometimes it dependent on the case scenario, but your spouse may have a life tenant, essentially, the right to live in a property while he's alive, and upon your passing, the children inherit. So there's different ways to approach that.
Great.
Well, let me say something about this, and this, I'm sorry, my camera's not coming up. This area is very complicated and probably would result in you needing to talk to a lawyer. Because what will happen is if, let's say life estate to spouse is what ends up happening, remainder to your kids, let's say that's what happened. The spouse has the ability to elect to take part of that life estate and convert it into a tenants in common. And then suddenly that spouse has 3/4 interest in the property and only 1/4 going to your kid. Maybe that's what you want, maybe not. There are ways, there's special language you can include in a deed to probably get what you want, but you're going to really, it's best to talk to a lawyer to make sure what you think is going to happen will happen.
Okay, great. Thank you, Judge. Next question. Do you have a checklist for trusts?
I'll answer that one. So in Orange County, I might as well just leave the video on. In Orange County, the trust cases are actually handled by our civil divisions because you're entitled to a jury on a lot of issues there. And I'm not aware that in our circuit that we have checklists for trust. It doesn't mean that other circuits might not have it. So you can obviously do a Google search, but maybe the attorneys know the answer. But in Ninth Circuit, I'm not aware of a checklist for trust.
All right, our next question is from an attendee who says, I'm still confused about the difference between the direct asset transfer and the Ladybird deed. They seem like the same after the owner passes. What's the difference? Are there differences in terms before death and after death, or both?
The Ladybird deed is a type of direct asset transfer to transfer real estate property.
And next question is, can the deed status be changed?
I assume maybe the status referring to maybe the way that it's recorded. If that's the case, then yes. So let's say it is currently recorded just you as a single person, you want to add someone to the deed. If that's what you mean, then yes, we can go ahead and execute a new deed to change the name on the deed as it reflects in the title.
Okay. Great. Next question. If your parent passed away that lived out of state, does not have a will, you had property and money in a bank account, your siblings hired an attorney, filed a case, but has not informed you about anything. The parent passed away 2 years ago. What can you do as the biological daughter of your dad's name is not on your birth certificate, if your dad's name is not on your birth certificate?
My suggestion would be to contact an attorney because you still have rights. So that would be my first suggestion, contact an attorney.
Yeah, that's a very tricky one. And again, we're trying to answer as many questions you have as possible. General questions, case-specific information is very, cannot get into that here during our forum. Okay, next question. If you have a will in another state and you have real estate in Florida, how would that work?
That's the ancillary probate option, essentially, that you have to submit the court documents to the local court here where the property is located, and also have all the certified documents from that state also provided here as well. And they'll go through that process of the ancillary probate for any real estate property.
Okay. Great. Follow up to grandmother passing in 25. She did not have a will. She did have a car, at least $10K in bank, no property. Shall I let the lien holder of the car know she passed? I want to keep the car. It's just myself and my sister. Sister agrees to me keeping the car since I was doing everything for her.
Yeah, that's going to be difficult to answer. Again, it's so case specific. I don't want to just, mislead her. So I would say, again, my suggestion would be to contact one of us or an
Yes.
attorney of your choice.
Okay. Okay, great. Next question. If I own a home with my son and his wife and I die, does my son automatically get the house? He is on the title.
Again, it's going to depend on how the deed is written.
Okay. Next question. How to change ownership of vehicles so that spouse can own vehicle when I pass. So how to change ownership of a vehicle so spouse can own the vehicle that would be stated in the will, correct?
The change of ownership for vehicle, I didn't hear that one.
Yeah, it will be in the will that you leave it to whoever you want. As far as the automobile, there's a section that you'll say the car goes to whoever.
Or you can take the death certificate right to the DMV as well and get it retitled.
Okay. Next question, with a Lady Bird deed, does the beneficiary have to pay the entire mortgage when you pass away? The 30-year mortgage, in other words, does it have to be paid off?
Somebody is going to have to pay that mortgage, so the property still will be subject to the mortgage.
Okay. Next question, does a marriage couple require two separate wills? A married couple.
Yes, absolutely. Two separate people.
Okay. Next question, can a widow, he asked to leave the house because she is not on the title? Oh, I'm sorry, can a widow be asked to leave the house because she's not on the title?
That one is going to be too fact specific. Again, a recommendation to speak to an attorney.
Okay, very good. All right, next question. What are the differences in fees for irrevocable trust, easy for me to say, versus revocable? Difference in fees for irrevocable and revocable.
It really depends on the, family dynamics, the different law firms, what your assets entail, if you fall between the, federal tax level. So it's hard to give you a direct number, but it's definitely going to be in the $2,000 or up, given the base of where you are, especially Central Florida, essentially.
Okay, and is there a difference between the two when paying taxes?
Yes, as far as how it's the approach to taxes, right? Because the irrevocable trust is an entity by itself upon the set off right away. Whereas revocable trust, typically you don't have to file a separate tax while you're alive as a grantor. So it really depends on what stage that we're addressing the tax implications.
Okay, next question. My wife and I bought our home before we got married. Don't know what that acronym is, automatically
It's
still in
joint
Florida or
tenancy
not?
with right of survivorship.
There you go, right of survivorship. All right, there you go. Is that automatically still in Florida or not?
Well, married couples are, again, tenants by the entirety, so we would have to look at the deed, but it should be a tenant by the entirety, which does apply just like the joint tenancy with right of survivorship. Judge Murphy?
I think obviously every case is different. A lawyer would probably recommend you redeeding the property to yourself so that you acquired the property while you were married, so that the presumption of joint tenants with right of survivorship. I think the question was, if you've already bought it and then later marry, does it automatically become joint tenants? You can avoid the problem by just redoing a deed, is likely what a lawyer would recommend, but every case is different. And without seeing the exact language of the deed as you wrote it, I mean, it might have said in anticipation of marriage, maybe that matters. So best to talk to a lawyer just to make sure that there's no problem.
Good, thank you. How is a trust funded? That's our next question.
I think Leroy answered that one already when she said you have to retitle your assets to the name of the trust.
Okay. This next question is, Sorry to ask again, if will is notarized but one witness name not readable and the readable witness and notary are dead, is will invalid?
Let me try to answer it this way. So, and then not about in a roundabout way. So what happens typically in a case is the will has to be admitted into evidence. And the way the will typically gets admitted to evidence, if you've hired an attorney, you do in addition to the will, there's a next document that's usually stapled to it called a self-proving affidavit. And usually in the self-proving affidavit, it once again lists the information, like the note that the decedent signed it, who the witnesses are, that they signed it all at the same time in each other's presence, and then the notary signs it. So if that document is done, it doesn't matter if any of the people's signature is not readable. What happens a lot of times is that self-affidavit has not been completed. And you just have, because a will only requires the signature of the decedent and two witnesses in Florida. So let's say you can't read either one of those signatures. Well, you have to, and you don't have the self-proof document to self-prove it, you're going to need one of those witnesses, or sometimes the personal representative, to do an oath to establish that this truly is the will of the decedent. If you have the personal representative who's able to do that oath, once again, it doesn't matter that those people's signatures are not readable. But let's say the personal representative named in the will is dead, and you have no personal representative named, you have no one who would be able to sign the document, the oath of the witness, that might cause that document not to be able to be proven and they're not be able to be admissible. But the simple question of just because you can't read one person's signature, there's no automatic making the will invalid. Now, every case, I keep saying every case is different. There might be some other factors that are not included in here, but the real question is, how do you get the will into evidence? Usually it's a self-proof document, which is separate from the will, or an oath of the witness saying that this will basically establishing that that was the will. Hopefully that answers your question. If not, write another one. I'll take another stab at it.
Thank you, Judge. Thank you. All right, next question. Sorry to ask again, if will is notarized, but one witness name not, oh, we already did that one, didn't we? All right, sorry. If a will was prepared and notarized in another state, but you have real estate in Florida, how would that work? We had something similar
That's
earlier
the
on that.
ancillary probate that I mentioned, that essentially you'd have to get all the documents from that other state submitted to the local court where the property is located to have the ancillary probate done.
Okay. All right, next question. When money is the only asset, do you need to file a will if your name is on the joint account?
If you do have a will legally, you still have to submit it to the court, but at least the accounts will go directly to you and avoid probate. But if you have a will in your hand and the person has passed away, you have to honor that timeline and submit it to the court. But the accounts, again, will go directly to you as the named beneficiaries.
Okay. Thank you. Can putting your home in a trust protect your home from HOA foreclosure?
No.
No.
Okay. Next question. Please explain mirror wills.
So, Karen, you go.
Wills that are identical. I leave everything to you, you leave everything to me, so identical wills.
Yes. All right. Next question. My parents just did a will, and the attorney did not include their tangible assets because she said that we can do that separately for our own car, jewelry, china, furniture, so forth. But what I'm hearing, that should have been included in the will. Is that correct?
Well, Florida law allows. Oh, Florida law allows a statute, and your will probably includes that says that any tangible items you can leave specifically in a separate sheet of paper as long as it's signed and dated. So, for example, you can say my 14-karat gold ring with specificity, and then sign it, and that is included in the will. So, more likely than not, your will has that language that says they can do so, and that's okay for tangible personal items.
Okay. All right, thank you. We're getting close to getting through the rest of our questions. So if you're with us, please don't leave, because at the end of our webinar here, we have a short survey for you to take that helps us for planning future webinars. Next question, can you show, Attorney Skyer's contact information. So Karen, you gave that earlier. I guess at some point we can send that to you. So I'll move on to the next question. I thought the right of survivorship with jointly owned property goes to full ownership of the surviving spouse. Does the surviving spouse have full rights with deed joint rights of survivorship? Any thoughts on that one for our legal panel?
I would have to see the deed, but again, it just depends on what the deed reads. So I'm not really understanding the question as it's posed.
Right of survivorship, jointly owned property goes to full ownership of the surviving spouse. Does the surviving spouse have full rights with deed joint right survivorship? Okay. Again, more specific. So next question, what is the process to put a purchase home under FHA loan into a trust?
By preparing a deed.
Okay. Next question, mortgage is paid off. Son and mom bought home together. Mom passed, brother lost will. What does husband that lives in home and paid the last 10 years of mortgage, next step in order to sell paid off home, sell the home, or can be redeed it without probate? Can we redeed it without probate?
And my recommendation would be to contact a lawyer on those fact specific cases.
All right. Yeah. So again, these very specific details, getting an attorney is the best step for you. As a beneficiary, would you save more on fees, taxes when inheriting assets from the deceased if they had an irrevocable trust or revocable trust?
I would recommend calling an attorney on one of those tax specific questions.
And a CPA as well.
Yes. Okay, next question. How can I get assets or access of a will that's been put in with a law firm?
I would say contact the law firm if you know who
Yep.
they are.
I mean, if it's filed with the clerk of the court, I'm pretty sure, and maybe the clerks would know the answer to the question, but if it's filed with the clerks, I believe it's public record, even if it's kept for safekeeping. But I've never had a look at one where the person hasn't passed away. So maybe, there we go.
Yeah, Michael.
So it's my understanding that the will for safekeeping actually isn't public record, but any other will is. So a will part of a probate case.
Okay. Down to our last two questions. So if anybody else has a pressing question, get it in now. All right. How can I get, okay, we already went through that one. So do you have to put in your will that your creditors be paid? I'm not referring to mortgages or car loans, but unsecured loans.
Whether you put it in there or not, I think the answer is that, again, I explained the creditor period. The creditor period here in Florida is going to be 30 days. So I'm sorry, 90 days. And so essentially, they would get paid if they file.
Okay, great. All right. That is actually all of our questions. We got through it. Okay, so we had a question about attorney's contact information for Karen Skyers. We are going to share that information with you. And again, you're looking for any of that information, you can watch the recording later to get a lot of this different contact information. But we will share that with you we can share that directly with who asked as well. All right. So thank you for joining us. Orange County Clerk of Courts Tiffany Moore Russell understands the importance of these conversations in our community. I hope it was helpful for you tonight. We hope these topics discussed were helpful, and a big thank you to all our presenters and panelists for joining us, staying late to continue to share this information that's helpful to the community. Once posted, again, you'll be able to view this video anytime you'd like on our social media platforms for the Orange County Clerk of Courts. As always, make sure to follow us on our Facebook, Instagram, Twitter, LinkedIn pages to get the latest updates. This will also be posted on our website, myorangeclerk.com. So thank you for joining us. And as I mentioned earlier, we'll have a survey that's going to pop up as soon as we end this. Please take that survey. Gives us feedback on different topics that you'd like to see in the future, and gives us feedback so we can look at what we're going to continue to do for these forums and some of the topics you'd like to see. So if you can fill that out at the end.